The right to vote, it feels like the absolute bedrock of American democracy, right? But how we actually protect that right, well, that's one of the biggest, most intense debates happening in the country today. And right at the heart of that storm is a piece of legislation called the John Lewis Voting Rights Act. So, in this explainer, we're going to dig into it. We'll look at the history, unpack the controversy, and figure out what it all could mean for the future of how we vote in America. All right, so here's our game plan. We're going to start with the original safeguard, the big one from 1965. Then we'll jump to the landmark Supreme Court ruling that really changed everything and what the world looked like after. From there, we'll get into the proposed fix on the table today, look at the debate around it, and wrap up with the big question, why does all this matter so much? Okay, let's dive in. To really get what's going on today, we have to rewind the clock all the way back to a law that was an absolute game changer for American democracy, the Voting Rights Act of 1965. So picture this, 1965. The Voting Rights Act is signed into law. And this wasn't just some minor tweak to the rules. It was a truly monumental piece of legislation. Its entire mission was to tear down the legal walls that had been built up for almost 100 years at the state and local level. Walls specifically designed to stop millions of people, especially Black Americans, from casting a ballot. Now, the real engine of this act was a powerful idea called preclearance. The best way to think about it is like a federal safety inspection for any new voting rule. If you were a state or a county with a long, documented history of discrimination, you couldn't just change your voting laws on your own. You had to get federal approval first. It was a way to stop discriminatory rules before they could ever take effect. And for almost half a century, that federal safety inspection system was just how things worked. It was the law of the land. But then, in 2013, a huge Supreme Court case called Shelby County versus Holder came along, and, well, it basically flipped the whole board over. So what happened? It was a super close 5-4 decision. The Supreme Court said that the formula used to decide which places needed that federal oversight, well, they said it was unconstitutional. The core argument from the majority was that the formula was based on really old data, like from the 60s and 70s, and it just didn't reflect, in their words, current conditions anymore. And this is where things get a little weird, legally speaking. The court didn't actually get rid of preclearance itself. The safety inspection was still technically on the books. But what they did get rid of was the formula, the list essentially, that told you which places had to go through that inspection. So you have a rule with no way to enforce it. The whole system was basically put on ice. Now, Justice Ruth Bader Ginsburg, in her now famous dissent, had a completely different take. She basically argued that the law's success was the very reason it was still needed. She made this incredible analogy. It's like throwing away your umbrella in a rainstorm just because you're not getting wet. The reason you're not getting wet is because the umbrella is working. In her view, the decrease in discrimination was proof the law was doing its job, not a sign that the problem had vanished. So, what happens when you pause that federal safety inspection? What did the world look like right after this decision came down? Let's take a look. Well, the impact was almost immediate. Several states that had been under that preclearance rule moved fast to put new voting laws in place. For instance, Texas rolled out a really strict voter ID law. North Carolina passed this big bill that, among other things, cut back on early voting and got rid of same-day registration. These were changes that, by the way, had been blocked before under the old system. And it wasn't just about the rules on paper. It was about physical access to voting. Reports found that in the 5 years after the Shelby County ruling, something like 1,000 polling places were shut down across the country. And a lot of those closures happened in counties with large African-American populations. The data also points to a growing gap in who is actually turning out to vote. I mean, the 2020 election had incredible turnout across the board, which is great. But when you look closer, the gap between white voters and non-white voters was 12.5%. And what's significant is that this participation gap has actually gotten bigger since the last presidential election before the Shelby decision. Okay, so all of this, the new laws, the polling place closures, the data, this is the backdrop for the legislative response. Congress wanted to create a modern fix, something that would directly address the Supreme Court's concerns. And that proposed fix is the John Lewis Voting Rights Advancement Act. So the main idea behind the John Lewis Act is to create a brand new, up-to-date formula. Here's basically how it would work. First, it looks back at a state's voting rights record over the last 25 years. Then, it counts up any court-proven, adjudicated violations. And finally, if a state racks up 15 or more violations, or just 10 if the state itself was behind one of them, then it goes back under federal preclearance for the next decade. But the bill adds another layer, and this is really interesting. It's something called practice-based preclearance. This is different because it would apply to the entire country, not just certain states. It basically flags specific types of voting changes that are known to be high risk for discrimination. We're talking about things like stricter voter ID laws, cutting multilingual voting materials, or closing polling places in diverse areas. Any of those actions, anywhere in the U.S., would automatically trigger a federal review. All right, so as you can probably imagine, this whole proposal is at the center of a massive national debate. There are really strong feelings on both sides, so let's get into the main arguments. Okay, let's break this down. On one side, critics say this is basically a federal takeover of elections that should be run by the states, and that it puts this huge burden on them. But supporters push back saying, hey, this is just restoring a system that worked really well for 50 years, and it's actually pretty streamlined. Then you have the argument that the new formula could be triggered by frivolous lawsuits. The rebuttal to that is that the law is really specific. It only counts final court judgments where discrimination was proven. And let me tell you, those are incredibly hard to win. And maybe the biggest debate of all, is widespread racial discrimination in voting a thing of the past, or does it just look different today, maybe more subtle? Now, about that argument that preclearance is an extraordinary burden. This is a really fascinating piece of data. Supporters of the act will point to the history books. Back when the system was fully up and running, the Department of Justice actually approved, get this, 99.86% of all proposed voting changes without any problem. So the argument is that the system wasn't some giant roadblock. It was a highly targeted tool that let fair changes go through just fine. So when you strip it all the way, this whole debate, it's not really just about formulas and legal clauses. It's about a really fundamental tension. Something that's right at the heart of how America is supposed to work. What it really comes down to is a balancing act between two huge principles. On one side of the scale, you have the idea of equal sovereignty of states, basically that all states should be treated the same by the federal government. But on the other side of the scale, you have the federal government's constitutional duty, a duty baked into the 14th and 15th Amendments, to step in and protect every citizen's right to vote from racial discrimination. And that leaves us with a big essential question, not just for this law, but for our democracy as a whole. How does a country like ours, how do we acknowledge our history, deal with our present-day realities, and write laws that guarantee, truly guarantee, that the right to vote is safe for every single citizen? That's the challenge. And finding the answer is what this entire fight is about.